Hello, everyone, and welcome to Uncivil Law. For today's story, we are dealing with immigration policy and changes by the Trump administration. The Trump administration recently tried to put in a policy that in order to claim asylum in the United States, you had to claim asylum in any country that you went through to get here. And the Ninth Circuit Court of Appeals is reviewing that determination to figure out whether or not that's lawful. Did the Trump administration validly say that you have to apply for asylum in other countries before applying in the United States? So we're going to read this decision from the Ninth Circuit, find out what's going on, find out what the Trump administration tried to do. Let's get started with this. On July the 16th, 2019, the Department of Justice and the Department of Homeland Security published a joint interim final rule without a notice and comment entitled Asylum Eligibility and Procedural Modifications, the Rule. With limited exceptions, the rule categorically denies asylum to aliens arriving at our border with Mexico unless they have first applied for and been denied asylum in Mexico or another country through which they've traveled. We describe the rule in detail below. The plaintiffs are a nonprofit organization that represent asylum seekers. They brought suit in district court seeking an injunction against enforcement of the rule, contending the rule is invalid on three grounds. First, the rule is not consistent with the Immigration and Nationalization Act. Second, the rule is arbitrary and capricious. Third, the rule was adopted without notice and comment. The district court found the plaintiff had likelihood of success on all three grounds and entered a preliminary injunction against enforcement of the rule with the effect of the four states with our border with Mexico. We hold that plaintiffs have shown a likelihood of success on the first and second ground. We do not reach the third, and we affirm. So here the Trump administration said that you couldn't claim asylum unless you had claimed asylum in the countries that you walked through. So if you're coming from Mexico, that's at least Mexico, unless you are a citizen of Mexico, I suppose. But otherwise, if you're coming from some other country, Central America, for example, and you're walking here, you'd have to walk through Mexico and presumably other countries along the way too, depending on where you come from. And so the Trump administration said you can't get asylum here unless you apply for asylum in one of the other countries. And the district court said, no, you can't do that. It's a violation of the rule. It's arbitrary and capricious. And the court agrees with it here, so we'll read further. In 1967, the United Nations adopted the protocol relating to the status of refugees, which largely incorporated the United Nations Convention relating to the status of refugees. The 1967 protocol and the 1961 convention define a refugee as someone who is unable or unwilling to return to his or her country of origin due to a well-founded fear of being persecuted for reasons of race, religion, nationality, membership in a particular social group, or political opinion. A decade later, Congress passed the Refugee Act of 1980, amending the Immigration and Nationalization Act. As the United States Supreme Court has twice recognized, one of Congress's primary purposes in passing the Refugee Act was to implement the principles agreed to in the protocol as well as the convention. So, yeah, Congress passed a law which echoed the sentiments, at least, of the United Nations agreement. So we passed a law that somewhat mirrored some of the principles of the United Nations protocol. So now we have a U.S. law that we can interpret, which is always helpful. Among other reforms, the Refugee Act codified in the 1967 protocol definition of refugee. In relevant part, the Immigration and Nationalization Act, U.S. law, defines refugee as persons outside of their own country who are unable or unwilling to return to that country because of persecution or well-founded fear of persecution on account of race, religion, nationality, membership in a particular social group, or political opinion. So yeah, this language is pretty much identical to the language from the United Nations, but it's now part of our law. The Refugee Act also codifies procedures for determining eligibility for asylum. It required the Attorney General to create an asylum procedure under which any alien physically present in the United States or at a land border or point of entry, irrespective of status, could apply for asylum. All right, so that is an important thing to note and should be noted. So there's a couple things that says and a couple things it doesn't say. What it does say is that you can apply for asylum anywhere at any time. So whether you're in the United States or otherwise, at a port of entry, for example, which is like a border control point, that's a port of entry. If there's border guards, you're at a point of entry. That would be a good example. Or if you or a land border. So if you're physically here, so you can apply for asylum. So if you're here illegally or undocumentedly or whatever, yes, you can apply for asylum. Now, that doesn't mean that you're here legally, though. You are here illegally, but you can still apply for asylum. So whether or not you're guilty of some other law, is not the issue, which you are because you're here illegally. But even though you're here illegally, you can still apply for asylum. So this is like a problem in some respects because some people, when they're caught, sometimes will scream asylum even if they're not, because they know that it's a ticket for them to be given a delay. But that is what the law seems to say. It's like no matter how you got here, no matter what your status is, you too can apply for asylum even if you're here illegally. So you may be going to jail, you may be doing other things, but you can still apply for asylum. All right, fine. Refugees, as defined under the operative law, are eligible to apply for asylum. The burden of proof to show refugee status falls on the person who is applying. To establish that the applicant is a refugee, the applicant must establish the race, religion, nationality, membership in a particular social group, or political opinion was or will be a central reason for the persecution. So you have to provide evidence and other documentation or whatever else it is, but you're the one who has to prove it. Subject to certain statutory exceptions, an alien who is physically present in the United States or who arrives in the United States is eligible for asylum. And there are some exceptions. So you may be able to apply for asylum regardless of legal status unless these things are true. These exceptions include an alien who may be removed to a safe third country, aliens who did not apply for asylum within 1 year. So if you're caught after 1 year, then you don't get asylum. You have to ask for it reasonably. And people who previously were denied asylum. So, the United States did think a little bit ahead. Did think a little bit in its rules. It's like you don't have to be here legally, but you do have to apply for 1 year. Now, how you prove when the person entered, if they entered illegally, is a whole other question, right? But yeah, if you're here more than a year, you can't get asylum. If you've been denied before, asylum. Or more critically to our present analysis, if you pass through a safe third country. So if you pass through a safe third country, you can't apply for asylum. So now we have to figure out what is a safe third country, because that's the operative issue for today's discussion. Two of the exceptions are directly relevant. First, an alien subject to the safe third country provision may not apply for asylum. Secondly, neither the Attorney General nor the Secretary of Homeland Security may grant asylum to an alien who was firmly resettled in another country prior to receiving the United States. So, if you fled somewhere and then you settled down, then you can't then come to asylum because you settled down. So you have to apply for asylum there. So those are the two things that apply. In 1995, the Attorney General promulgated a regulation allowing discretionary denials of asylum in certain circumstances where asylum or its near equivalent was available in a safe third country. The relevant law, the Safe Third Country Bar, provides as follows. The law dealing with authorizing refugees to apply for asylum, so people who apply for asylum, this does not include an alien if the Attorney General determines the alien may be removed pursuant to a bilateral or multilateral agreement to a country in which the alien's life or freedom would not be threatened on account of race, religion, nationality, membership, or political opinion, and where the alien would have access to full and fair procedure for determining a claim of asylum or the equivalent temporary protection. As indicated from the italicized language, there are two requirements that must be satisfied before this third country bar applies. First, there must be an agreement between the United States and another country to which the alien would be removed and which the alien would not be subject to persecution. Second, the country to which the United States has an agreement must allow access to a full and fair procedure for determining eligibility of asylum or the equivalent. And in 2002, the United States entered a safe third country agreement with Canada. At the time that the rule that is at issue here was issued, the United States has entered into no other safe third country agreements. So safe third countries are defined in statute, and they're defined to include those countries to which the United States has a bilateral or multilateral agreement. And we have reached an agreement with Canada. So if you're illegally immigrating to the United States through Canada, which, I don't even begin to know how that occurs, but if you are, then you can't apply for asylum here because Canada is considered a safe country. And presumably, Canada considers us a safe country, although as of recently, who knows. But yes, we've entered into an agreement with Canada where we consider ourselves to be mutually safe countries, but no other countries. So the Attorney General was trying to get around the requirement of the statute by just unilaterally declaring it. Mexico is now a safe country. But that doesn't seem to be in operation with the law. The law seems to require the agreement. So the question is, can the Attorney General do this? Can the Attorney General just declare other countries to be safe even if there's no agreement, which the statute seems to require? Take your bets now on that issue, and you can debate which is going to win out over the other. Will Chevron win out so that the agency can do what it wants, or will the Ninth Circuit win out so that they can't? Take your bets now on which is going to be the more operative provision, I guess. On July the 16th, 2019, the Department of Justice and Homeland Security jointly issued an interim final rule governing aliens who travel through a third country before reaching the southern land border of the United States. Notwithstanding the provisions of law, any alien who enters or attempts to enter or arrives in the United States across the southern land border on or after July the 16th, 2019, after transiting through at least one country outside the alien's country of citizenship, nationality, or last lawful habitual resident shall be found ineligible for asylum. So they just tried to promulgate this as a rule without notice and comment, too. So that's the thing. In effect, the rule requires Guatemalan aliens reaching our southern border to apply for and then be denied asylum by Mexico before they're eligible to apply for asylum in the United States. The same requirement applies to aliens who arrive in Mexico from other countries by plane or ship before traveling to our southern border. Aliens traveling overseas from El Salvador, Honduras, or other countries south of Guatemala must apply for and be finally denied asylum by Mexico, Guatemala, or another country through which they traveled. The rule further provides that aliens ineligible for asylum under the rule are automatically and conclusively determined not to have a credible fear of prosecution in their home country. If an alien is found to be an alien that is described as ineligible, then the asylum officer shall enter a negative credibility field determination with the alien's application for asylum. So, yeah, the United States federal government, or more specifically the Attorney General, tried to do this unilaterally. Now, I am sympathetic in large part to the Attorney General's issues here. That being the case, politically, even though I politically agree with it, I legally agree with the court. So this is another case where my politics and my legal acumen lead me to different conclusions. So just to show you that it's possible, your politics and law can be divorced from each other. So being a good conservative politically, or conservative leaning politically, I agree with the Attorney General. But being a good conservative legal scholar, of which I am much more loyal to, I agree with the Ninth Circuit Court of Appeals. Because the statute is pretty clear on its face. Also, I just hate Chevron, as we all know. And so I wouldn't be giving them any latitude anyway. So there's that. But yeah, I'm sympathetic to the Attorney General on this one on a political level, because it's like if you're leaving a country that's war torn or whatever, you would think like any port in a storm would do. If you're truly under threat in your home country, which may very well be the case from whatever the situation is, from violence, you would think that you would welcome any port in the storm. But if you're traveling, say, for example, all the way from Venezuela to the United States by foot, which you often are, you'd have to think that one of these many countries along the way, including, for example, Belize, which is also closer, might be sufficiently friendly for you to feel safe in. But you're coming to the United States. So it's like, how much credible fear can you really have is the Attorney General's point, which I totally understand. On a political level, I totally understand. It's like, if you truly felt like your life was under imminent threat of death or grievous bodily harm, like, wouldn't you feel safe just crossing the border? But no, we want to cross several other borders for several thousand miles before we've reached the United States, and only then do we feel safe. It's like, how much fear were you really in the first place if you cross several other nations to get to the United States? So on a purely political level, I agree with the Attorney General. It feels a little bogus to me that, if you're traveling from deep in South America and you traveled all the way here by foot, that there was no safe harbor until you got to the United States. This is the only safe place you have in your flee from the utter repression of whatever your homeland is. It feels a little bit dubious. There was nowhere else safe for you to go along the way. So there's that. So on a political level, I agree with the Attorney General. However, as a good conservative legal scholar, I am unfortunately forced to agree with this Ninth Circuit Court of Appeals, because the statute is pretty clear on its face. The statute language is clear. It requires, by its own clear terms, there to be a multilateral or bilateral agreement in order for there to be a safe harbor provision. The statute is clear. And under this lawyer's jurisprudence interpretation, you definitely can't expand beyond a statute's clear language. So even Chevron shouldn't go that far. So yes, politically, I actually agree with the Attorney General, but legally, I disagree with the Attorney General. So I guess this shows you that sometimes you can actually reach legal conclusions you don't want to reach that even defy your politics, because it's like, yeah, that's what the law says. The statute's clear on its face. Not a lot of ways to interpret that. So, yeah, it may be the Ninth Circuit, but the Ninth Circuit isn't insane. They are actually reading the plain text of the statute and applying it. So, yes, I, conservative legal scholar, agree with the Ninth Circuit. I a little bit hate my life, but that's where we are. On a motion for a preliminary injunction, the plaintiffs must make a threshold showing of 4 factors. Plaintiffs must show that they're likely to succeed on the merits, that they're likely to suffer irreparable harm. Without relief, the balance of equities tips in their favor and an injunction is in the public interest. This 4-factor test should seem familiar because it's the 4-factor test we use in all the injunctions ever. To show a likelihood of success on the merits, the plaintiffs must show that the rule is likely to hold an unlawful agency action under the Administrative Procedures Act. The Administrative Procedure Act provides in relevant part that a reviewing court shall hold unlawful and set aside agency actions, findings, and conclusions found to be arbitrary, capricious, and abuse of discretion, or otherwise not in accordance with the law, in exercise of statutory jurisdiction, authority, or limitations, or short of statutory right, or without observation of the procedure required by the law. Plaintiffs allege the rule is unlawful under the Administrative Procedures Act on 3 grounds. First, the statute and its rule is not in accordance with law and is in excess of the limitations because it's not consistent with the text of the statute. Second, under the statute, the rule is arbitrary and capricious because it runs counter to evidence before the agency. And third, under the statute, the rule was adopted without observation of the procedure required by law because it was adopted without notice and comment. The district court agreed on the first 2 grounds, we affirm on the first 2, and do not reach the third. The rule creates a bar to asylum, in addition to the asylum bars already existing in the law. To justify the additional bar, the government relies on a different element of the statute, which provides the Attorney General may, by regulation, establish additional limitations and conditions consistent with the section under which an alien shall be ineligible for asylum under the paragraph. An agency action must be set aside if it is not in accordance with the law or an excessive jurisdiction, authority, or limitation. When an agency violates a statute by a federal agency, we generally apply Chevron. My favorite case of all time. We generally apply Chevron to determine whether or not to defer to the statute. Yay for Chevron. Yay. The question before us is whether the rule is consistent with the statute as required by this other part of the statute. For the reasons that follow, we conclude it is not, and the rule is therefore not in accordance with the law and is in excess of the statutory limitations. The safe third country and firm resettlement bars limit an alien's ability to claim asylum in the United States when other safe options are available. These 2 asylum bars are consistent with core regulatory purposes of asylum, which is to protect refugees with nowhere else to turn, because by definition, an applicant barred by a safe place provision has somewhere else to turn. A critical component of both bars is a requirement the alien's safe option be genuinely safe. The safe third country bar requires that the third country enter into a formal agreement with the United States. The aliens will not be persecuted on account of the protected grounds, and the aliens will have full and fair access to an asylum procedure or the equivalent in that country. The rule superficially resembles the safe third country bar in that aliens are subject to rule are in a third country, and they must have applied for asylum in that country. Similarly, the safe third bar under the statute allows the United States to deny asylum on the ground they may be removed to and apply for asylum in a third country. But entirely absent from the rule are the requirements that there be a formal agreement between the United States and the third country and there be a full and fair procedure. Yeah, I unfortunately agree with the Ninth Circuit Court of Appeals on this one that, yes, the statute is fairly clear on its text. You know, it does say that you have to have an agreement, and the other section says you can only do stuff that's consistent with the law, and so this doesn't make any sense. So, yeah, you can't just declare third countries to exist. You actually have to enter into an agreement with a third country, which, at least at the time this was decided, was only Canada. And I know Trump wants there to be an agreement with Mexico, but I don't know the degree to which that exists or not, but it's not relevant, at least when this case was decided. So, if the attorney's discretion to add limitations and conditions for asylum were the same as his discretion to deny asylum to eligible aliens, the consistent with language would be redundant. Yeah, so it wouldn't make any sense. So if the authority was the same, then with the authority wouldn't be making any sense. So under the canons of construction, we should avoid an interpretation that would produce superfluousness. Yeah, that doesn't work that. But even without resort to the canons, can be consistent with was not intended to be just mere surplus. The touchstone of arbitrary and capricious review is a reasoned decision-making. Consistent with the core regulatory purpose of asylum to protect refugees with nowhere else to turn, the rule must ensure some degree of safety for aliens barred from asylum. An agency must examine the relevant data and articulate a sufficient explanation for its action. Normally, an agency rule would be arbitrary and capricious if the agency relied on factors which Congress had not intended it to consider, entirely failed to consider an important aspect of the problem, offered an explanation for its decision that runs counter to evidence before the agency, or so implausible it could not be ascribed to a difference of view or product of agency expertise. In promulgating the rule, the agencies entirely failed to consider an important aspect of the problem. Further, the agency's conclusion that aliens barred by the rule have safe alternative Mexico was counter to evidence before the agency. We have held in a long line of cases that failure to apply for asylum in a country through which an alien has traveled has no bearing on a validity's claim for asylum in the United States. For example, we wrote in a prior case that an asylum applicant's failure to apply for asylum in any of the countries through which he passed or which he worked prior to his arrival in the United States does not provide a valid basis for questioning the validity of the persecution claims. The fact that an alien might prefer to seek asylum in the United States rather than Mexico or Guatemala may be reflective of the relative desirability of asylum in these countries, but has no bearing on the validity of the underlying asylum claim. The government argued in the district court that an alien's failure to apply for asylum in a country through which the alien had passed can be illegitimate, indeed, the sole factor to be considered in determining whether an alien has credible fear of persecution and thus eligible to apply for asylum in the United States. The government provides us only a single record citation in support of the rule's categorical assumption that an alien subject to the rule does not have a valid asylum claim if they have not previously applied for asylum in either Mexico or Guatemala. The citation is to a newspaper article reporting that Central American migrants traveling through the United States stated their ultimate destination was the United States. The article does nothing to support the rule's assumption. The article does not even remotely suggest that aliens' preference to apply to asylum in the United States rather than Mexico had any bearing on whether they had credible fear of prosecution that could support a valid claim to asylum. In sum, the agency's conclusion that aliens' failure to apply for asylum in Guatemala or Mexico justifies an assumption that an alien does not have a valid asylum claim, and categorically adverse credibility finding ignores a long line of cases holding that aliens are not required to apply for asylum in countries they pass through on their way to the United States, ignores the fact that a preference for asylum in the United States rather than Mexico or Guatemala is irrelevant to the merits of the asylum claim, and ignores extensive evidence in the record documenting the dangerous conditions in Mexico and Guatemala that would lead aliens with valid asylum claims to pursue those claims in the United States rather than in those other countries. We hold the plaintiffs are likely to succeed on the merits of their claims. The rule is not in accordance with law and in excess of the statutory limitations because it's not consistent with the statute. The rule is also arbitrary and capricious because it runs counter to the evidence before the agency and entirely failed to consider aspects of the problem. We further hold the plaintiffs have shown that they will suffer irreparable harm, the balance of equities lies in their favor, and the injunction is in the public interest. Finally, we hold the district court did not abuse its discretion in entering an injunction covering the 4 states along the border with Mexico. So that is the end of the case of East Bay Sanctuary Covenant versus William Barr. In this case, the Attorney General tried to promulgate a regulation that said if you went through Mexico that you couldn't come to asylum in the United States. But unfortunately, the statute is written pretty plainly on its face. So while politically, I think that was probably a good idea, unfortunately, the way the law is written does not allow that latitude. So the Ninth Circuit did reach the right conclusion in the statute because there was no bilateral or multilateral agreement, and so you can't just do something. And to the extent you could, they would then follow the Administrative Procedures Act, but that doesn't really matter because it violates the law anyway. So yeah, this injunction is valid. You can't just do that. You have to allow them to apply for asylum, and that is the end of the coverage of this case. Thank you for joining me as we both read this case together and now better understand the law. If you're enjoying this legal education content, please subscribe to this channel. It really helps us grow. And check out one of our other videos, including the one that's currently being displayed on the thumbnail on screen. Thank you so much for your continued support. And until later, my friends, cheers and goodbye.